the single judge hold another examinations, giving them time to do the training, which is completely contrary to 28. 28 last sentence. Any other candidate who was not in service as on 10th August 17, that is writ petitioners, cannot be considered to be at par with the 2 years DLED. Kindly come to 33 thereafter. As observed herein before, as observed herein before, it is clear that the judgment of this court in the case of Jaivi Singh unequivocally held that the entire scheme emanating from the NCT recognition order dated such and such was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualification prior to April 2019, they would not have continued to remain in service and would have faced dismissal from service. As such, this is the condition. Any teacher who was in service as on 10th August 17 and who acquired the qualification of DLED by way of 18 months program through NIOS prior to 1st April 19 is a valid diploma holder and at par with any other teacher who has been completed the 2 years DLED program. My respectful submission is this. Had the writ petition been filed prior to 19, no difficulty.
Have you taken? You couldn't have taken this ground in the appeal.
Well, that is.
You are now going beyond that.
Your Lordship.
New points.
Yes. Your Lordship.
This is not the subject. You have not taken this ground in the appeal.
May I say this? May I say this? Would your Lordship genuinely think that I should not take this point? Then I will not say any single word.
That is choice is up to you, Mr. Dhar. You are arguing something
which
was not there.
May I say this?
Not even there in your appeal.
No, that is there. May I say this?
Where is it? Show us one ground that you had a premeditation that Supreme Court in future years will decide.
Kindly allow this. Kindly allow.
Unnecessarily elongating the issue.
This is not unnecessary.
This is because that is one say you are saying your writ petitioners have not pleaded anything and they are taking this.
May I say
now you are saying that no, though I have not pleaded, I will take this.
No. Kindly allow me to say what I am.
I have allowed you. Come to the next point.
But I will come, but I have not finished this point. Lordship,
we understood.
But I am not join the practice
to test, or this is important. This has come in, or teaching experience in case of para teachers. So aptitude test is no longer necessary for a para teacher, and this is where the learned judge went wrong.
No, it is either or.
No.
Either it can be aptitude.
No. Well, may I read it again? Interview and aptitude test, or teaching experience in case of para teachers. It is aptitude test or teaching experience for the para teachers. That means aptitude test for non-para teachers. But so far as para teachers is concerned, it is teaching experience.
And in the next clause, that para aptitude.
Can I take the rule itself? Because this is not that something new has come up by the Supreme Court. It was there very much part and parcel of the rule. Every time my endeavor is this. Kindly, I may not be able to express myself. But my endeavor is this, that once a litigation is filed, then rights of the litigators is of that date itself, and that is 22. And the window created by the Supreme Court based on the NCT several orders, that window is finished by 19. Now, right before the learned single bench, this judgment was not there because there was a contrary view in present. But today, all over India, every teacher who are appointed and fulfilling these three conditions, they are treated at par because of paragraph 33.
We understood you.
And
what more you have to
now, Lordship, kindly look at this. Kindly see this. Kindly take my lord, the copy of the rule, possibly with your Lordship. Kindly take the rule. Rule 6.2 and 6.3. Copy of rule.
That has to be done within 2 years.
Because that this is directly recognition of Rule 6.3,
Yes.
because
By
the,
Rule 6.3, they have completed, they have those appointed, they have completed the training.
but we did not have any seal of the Honorable Supreme Court. All I'm trying to say that we did not have a seal of the Honorable Supreme Court of at par. Now that seal came in 2025, which has a retrospective effect in understanding of the law before a Honorable Division Bench, when this Honorable Division Bench is deciding. This is my point. My first three judgments was that this is during pendency.
Yes.
This, well, copy of the rule Lordship might be having this.
It is out.
2016.
এইটার সাথেই তো মিলে, এইটাই আছে তো।
Well, I have a separate copy also. Lordship might have marked.
Yes. Yes.
Yes, Lordship, kindly see 6.2. I'm not reading entirely because it has been read several, only the last line. Read with relaxed qualification issued by the ministry from time to time and pass the T8. So, and 6.3, that 2 years.
Yes.
So I will conclude this point by after saying this. So Lordship may kindly think this, that there was an existence of contingent condition to be fulfilled under 6.3. I have fulfilled by April 19. Having fulfilled by April 19, there I use my metaphor, I have become a butterfly, no more a caterpillar. But this single judge has treated me as a caterpillar.
Yes.
That is wrong because of paragraph, Lordship, kindly take the paragraph 22 of the Honorable Single Judge's order. It goes directly contrary to this, the law declared by the Supreme Court. Kindly take paragraph 22 at page 624 in the paper book.
Yes, read it. Third.
Paragraph 22 runs completely contrary to paragraph 28 of Kaushik, because paragraph 28, the Honorable Supreme Court had held this is only available subject to fulfillment of 3 conditions. But here the learned single judge gives a separate condition. Kindly look at time of recruitment, including candidates who have obtained training qualification in the meantime, within a period of 3 months from date. This is totally going contrary. From date only for the candidates who participated in 16. Kindly have a look at paragraph 28 of Kaushik. So therefore, learned single judge gives time, even 3 months more, much after 19.
Yes.
Kindly take the one sentence of paragraph 28. The last sentence of 28.
Yes.
Any other candidate who was not in service, that's a writ petitioner, on 10th August 17 cannot be considered to be at par with the 2 years DLED. So therefore, window was there, 3 conditions were there, it is sealed. Nobody after April 19 cannot make himself trained. Not possible as long as this judgment stands. I am over on first point. My second point. If I use this word, the Honorable Single Judge completely ignored the statutory word natural in Rule 2C of in teaching test. Kindly see 2C. Two C is never a test.
Yes.
Well, my second point is the Honorable Single Judge completely ignored a particular word in the definition of 2C, which changes the entire color of this. Kindly see 2C. 2C never says about the aptitude test. It's a natural. First, Lordship, take it.
Yes.
Well, definition is aptitude test means a test, kindly mark, to assess natural teaching ability of a candidate.
Mm.
It is not a separate test at all. Kindly take the examples of we often have in our college, the extempo debate competitions, where the judges take a decisions based on assessment of overall presentations, content, maybe oratory. So assessment has to be under two categories: viva voce and the natural ability of a candidate. Sorry, natural teaching ability. Well, I was trying to understand that what does it mean of the natural, because what's the difference between? Lordship kindly takes the blacks. Lordship may take us a very, very common understanding while Lordship hears out the matter from the advocates. There are content, there are laws. Lordship under, looks into that. Simultaneously, Lordship also sees. I think this is a very, 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 as a Homo sapiens, we get that. The natural ability of the person, whether to communicate or not. So my submission is, it should be one test. In the test, there would be questions. While the interviewee answering the question, the interviewer would, in addition to the correctness of content, also assess, does he have a natural ability to teach? That's what 2C says. Lordship, may kindly have a look at the definition of this. In black.
Did your interviewers understand this?
But I will satisfy your Lordship.
Tested by persons who were not even qualified to understand that much of
Well,
things.
they understood. But one of the examples, Lordship may be shocked. Lordship may be.
Making an argument. Now you kindly go through the definition, and definition will show that it is not a segregated test. Interview and aptitude was tested. It is only the nature of question which was put is to be different.
It is to be segregated assessment. Kindly visualize. I don't say that there should not be any test for natural ability. I don't say so.
We are asking you, was this done?
It was done. I will show from the evidence also.
It was
Lordship would be surprised. On every fact, I shall be satisfying your Lordship's conscience. I am not going to take any technical points. Kaushik was, of course, maybe a technical point. But most likely, I would be able to persuade your Lordships that on fact.
What is your argument
Yes.
to that? That interview and aptitude have to be taken in a composite manner.
I say this. how a natural ability can be assessed. Kindly visualize.
You tell us.
Yes. I say that if a test is exclusively for a test for judging natural ability, then you kill the naturality of it. Kindly think over it. Lordships are testing the lawyers. Whether lordships require a separate test for the lawyers to understand